Florida really woke up today and decided that independent creators are not real journalists, which is wild considering nobody under 40 is sitting down to watch cable news unless they lost the remote and gave up. And the judge was not subtle about it either. She basically told every creator online to sit down and hush unless a corporation signs their checks, then gave a polite little nod like, "Thanks for the content, but legally you are about as protected as a guy yelling breaking news through a window screen." And that is how this whole ruling felt. Calm, direct, surgical, almost like she had already made peace with the fact that the law is ancient, and she was just applying it without bothering to update its firmware. But underneath that calm tone, this thing had teeth. Not sharp ones, old ones, fossil ones, the kind that tell you the statute was written when people still thought the internet was a passing fad. Popcorn Planet walked into this thing, saying they report news, investigate claims, interview lawyers, review filings, analyze court documents, break information down for the public, basically all the work regular reporters do. The judge listened. She considered. And then she opened the Florida Journalist Privilege Statute and sliced the argument into neat little pieces. Because that statute is old. Old in the way law books get old. Old in the way dial-up internet feels ancient. You look at it and you can practically hear the AOL starter disk screaming from the past. It lists newspapers, magazines, wire services, corporate newsrooms, radio, the stuff that dominated the media landscape when shoulder pads were a thing. What it does not list is the entire digital universe we all live in now. No YouTube, no independent channels, no online investigative platforms, nothing that reflects modern reporting. So the judge read the statute, compared it to Popcorn Planet's setup, and said, "Sorry, but the law has not caught up to you yet, or at all, so you do not qualify." Translation: if you do not get a paycheck from a corporate outlet, Florida does not consider you a journalist. And that is the part that makes the whole ruling feel heavier than its page count suggests. Now, what does this actually mean for the Blake Lively case? Here is the thing people need to understand. This order does not accuse Wayfarer of anything. It does not implicate Baldoni. It does not validate any of Blake's allegations. The judge did not even blink in their direction. This was not about them. This was not about any supposed coordination or messages or smear attempts. None of that was considered. None of that was evaluated. None of that was even legally on the table. The entire question was whether Popcorn Planet counts as a journalist under Florida's privilege law. Answer: no. Reason: the statute is prehistoric. Because of that, the judge denied their motion to quash. And because of that, Blake gets to see the documents she subpoenaed. That is all. That is the whole impact. She does not get a win on the merits. She does not get a ruling that confirms she is right. She just gets access. And let me tell you, access is everything in litigation. Not victory, not vindication. Access. When you have access, you get to look, you get to evaluate, you get to guess better, you get to prepare smarter. That is why discovery fights are the blood and guts of legal wars. The side with more information usually has the better footing, even if they are not guaranteed to win anything. So Blake gets a tool here, a small one, but a tool. Whether it helps her or not is a separate question entirely. Now let me say this again because people online love to hallucinate drama out of paperwork. This ruling does not help Blake prove anything. This ruling does not hurt Wayfarer. This ruling does not box in Baldoni. There were no findings, no conclusions, no shade thrown, no judgments of character or intent. The entire decision was procedural. But the part of this ruling that actually matters, the part that should have every independent creator paying attention, is the precedent. Florida just declared with a straight face that journalism is defined not by what you do, not by what you report, not by who you inform, but by who signs your paycheck. Corporate payroll equals journalist. Self-employed equals hobbyist. That is the entire worldview baked into this statute. And that is a problem, not just for Popcorn Planet. For every creator who spends their nights digging into cases, reading filings, reporting facts, verifying information, interviewing people, posting updates, doing the real work that audiences trust far more than the polished monotone reading from a teleprompter on the 6 o'clock news. Florida basically told all of them that none of that matters. You can do every part of the job. You can outperform traditional news outlets. You can break information faster. You can inform more people. You can reach more homes. None of it matters unless you have a corporate parent company stamping your work with approval. Creators are reshaping the media landscape. Legacy outlets are losing relevance. Entire newsrooms are shrinking. People get their information from creators because they trust them more. But the law is still sitting in a folding chair from 1987, pretending none of this is happening. This ruling shines a spotlight on that disconnect. And it is not a flattering one. But let us talk about Andy for a second, because here is the part the entire internet seems to forget. He can appeal. He does not have to accept this ruling as the final word. He can challenge it. He can drag the statute into a higher court and force people to confront the fact that the definition of journalism has not been updated since Blockbuster was thriving. And honestly, if he goes that route, things get interesting fast. Because the minute this becomes a fight about the definition of journalism itself, Florida is going to have to stand there and explain why a dying industry gets protections, while the platforms that actually inform the modern public get nothing. And that explanation is not going to age well. Florida's definition wasn't the only problem. The privilege log situation was its own mini disaster. The judge walked through it like someone reviewing a grocery list written on a napkin. She pointed out entries that spanned half the year with descriptions so vague, they might as well have said stuff happened. And when Andy's lawyer tried to argue that it was nonsense or absurd to expect him to itemize individual messages, she didn't soften her tone or hide behind polite courtroom phrasing. She said he was incorrect on the law, flat out, no sugar added. And that mattered because the privilege issue could have been a separate fight entirely. Even if Andy had qualified as a journalist under a more modern statute, his privilege log still had to meet the standard. Judges need specificity. They need enough detail to evaluate each claim without exposing the privileged content itself. You cannot just hand them a stack of months-long message threads labeled privileged and expect them to nod along. That is not how privilege works. That is not how Rule 45 works. And the judge made that very clear. The end result was brutal in a quiet way. Because of the insufficient log, the privilege was considered waived, not limited, not reduced, waived. She basically said, if you want the protection, you have to follow the rules for invoking it. And Popcorn Planet didn't. So even if Florida's statute were written by someone who had heard of YouTube, and even if Andy had landed inside the definition of a protected journalist, he still would have lost this specific battle. The privilege argument collapsed under its own paperwork before anyone even touched the merits. There is a reason traditional outlets have not rushed to cover this. They know exactly what it means. An appeal does not just revisit the ruling, it shines a light on the foundation. And that foundation is cracked. Cracked enough that an appellate court might look at it and start asking questions lawmakers have avoided for decades. Cracked enough that a higher panel might finally say what everyone already knows. The public gets its news online now. The legal system cannot pretend otherwise forever. And that is where Andy comes back into the picture. He does not have to take the loss and walk away. He can push this up the chain. He can make Florida explain why a creator with a larger audience than half the newspapers in the country gets treated like a guy ranting in a parking lot. He can force a real conversation about modern journalism. And once that conversation starts, it is not going to stop. Blake got what she needed. The defense stays unbothered. But the real plot twist is sitting quietly in the last line of the order. Andy can appeal. And if he does, this stops being a small procedural ruling and becomes a legal referendum on whether independent creators deserve the same protections as the dying newsrooms they keep outperforming. If Florida thinks creators will not fight that, they have not been paying attention.